I was recently asked, how do I make it so that my loved ones don't have to go to court in order to access the money I have specifically saved for them to handle my affairs after my death? This is a great question because it's fantastic if you were able to save a ton of money for them, but what good is it if they can't access it? First, I want to start by saying I'm not a lawyer and this is not legal advice. I'm arming you with information that you can then take to your estate planning attorney and make the best decision for you and your family. There are a few ways I can think off the top of my head that they can gain access to that money directly, and that would be through a life insurance policy. If they are named as the beneficiary, they simply prove that you have died and they prove who they are, and a check is cut to them. Most often, a retirement account works the same way. If they are designated as your beneficiary, they will gain access to that money without question and without having to involve the courts. A POD is a person who is payable on death, and that is someone that we can all signify right now on our bank accounts. Anybody can walk into their financial institution and say, I want to make so-and-so my POD. This person does not have access to any information, any of your financial data or your money or anything while you are alive. They have to prove that you have died, they have to prove who they are, and then they can have immediate access to your money. Death is expensive. There's the transportation costs needed for the executor. There are childcare costs, pet care costs, the house, the car, the bills, the debts left over. It's not just about making sure that your burial or cremation is covered. Death is expensive, and that money has to come from somewhere. If you don't want your loved ones having to shell out the money and just hope that they get reimbursed, you can take care of it for them by choosing one of these options. Or you might consider putting your money and your assets in a trust instead of in a will, thus foregoing the probate process.